Hello, everyone, and welcome to today's Our Best webinar. My name is Anna Kate Bogarts, and I'll be your webinar moderator for today. Today, our webinar is titled The Multidisciplinary Team Approach to Child Advocacy and the Role of the Mental Health Provider, led by Marquette Humphreys, who is the MDT Project Director at the Children's Advocacy Centers for Arkansas. So I'm really looking forward to hear more about that. But before we get started, I wanted to let you know a little bit about the Our Best program and do some basic housekeeping announcements. So Arkansas Building Effective Services for Trauma, or Our Best, is a state-funded program at the UAMS Psychiatric Research Institute. And our aim is to improve mental health services for children and families who have experienced trauma. We work closely with multiple partners, including the Children's Advocacy Centers of Arkansas, to build a more trauma-informed state. And we're probably best known for providing training to mental health professionals on treatments that help children and families recover from trauma. If you have a question throughout the webinar, we plan to get to that at the end, but feel free to type that into the Q&A box, and we'll do our best to get to those questions at the end of the session. If you want to use the chat, go for it, have fun. But if you want your question answered, just make sure you put that over in the Q&A. If you'd like to earn a CEU, make sure you stay to the very end, and I'll give you some instructions and a code that you'll need to get that. So just hang tight for that. We are recording this webinar which we'll upload onto the Our Best YouTube channel. So check that out if you'd like to share that with your colleagues or check it out again. We'll hope to get that up in the next few days. So that is about all I have for housekeeping. So I think I'm going to turn it over to you, Marquette. Oh, there you are. Couldn't hear you for a second.
Can you hear me now?
Yes.
Okay. Just want to thank everybody for joining me today to discuss the MDT approach to child advocacy and the role of the mental health professional on the team. Just a bit about myself. My name is Marquette. I am the statewide MDT project director with the Children's Advocacy Centers of Arkansas. I have been with the state chapter since 2021. Prior to joining the state chapter, I'm a retired law enforcement officer, and I served as a senior investigator with the Crimes Against Children's Division of the Arkansas State Police. A little bit about my educational background. I hold a Juris Doctorate with specialty in juvenile, family, and criminal law, and master's in public administration, bachelor's in psychology and criminal justice, and an associate's in law enforcement administration. So that's kind of landed me here in my role as the MDT director and working with our partners. What I'm bringing here for you today is just to discuss the MDT history and overview, the approach and benefits of the MDT, and just some basics about the multidisciplinary team, its membership, the mental health professional on the team, your role in reporting, and how that works with our case flow and case reviews. So the multidisciplinary team approach and the CAC, or Child Advocacy Center model, exist in every state. National surveys show that MDTs informally began in 1958. There were 3 of them. By the 70s, there was near 500 MDTs, and by 1985, there was nearly double that, but these existed in hospital-based settings. In 1985, Bud Kramer, who's a former prosecutor out of Alabama and congressman, developed the CAC model of the MDT approach in Huntsville, Alabama. They were initially introduced as this prosecutor-led approach. Arkansas adopted this legislatively in 1991. And in 2021 is when the operational responsibility of the MDT project was acquired by the Children's Advocacy Centers of Arkansas. Previously, it was managed by the commission under UAMS. So kind of what led Bud Kramer to creating this approach for the child abuse cases in 1985 is that many professionals involved in child victims were not communicating with each other. Medical exams were incomplete. They are often performed in hospital emergency rooms after the children were kept waiting for hours, and children and their families were bounced between agencies. And there was an acknowledgement that the system was re-victimizing the children. So the MDT model came about as a result of our failures. Child abuse cases were seeing low prosecution and conviction rates due to investigations experiencing lack of communication between the agencies, lack of coordination between the agencies, a lack of cross-training that was happening between the disciplines, and just a lack of knowledge. Vital information was not being shared between the appropriate team members, or what is now recognized as MDT members. We found that kids were facing duplicative interviews that was causing more trauma. So they would get interviewed by almost every member on the team during the course of a case, whereas now we try to reduce how many times a child is being interviewed. That just created confusion as to who is doing what on a specific case. And so with all these issues, it was recognized that in order to effectively respond to these failures, that a unique partnership was necessary. So recognizing this nationally and bringing this to Arkansas found that it was necessary to legislatively require an MDT approach. So the language in state law is that the Department of Human Services, or DCFS, and the Department of State Police, which is going to be your Crimes Against Children's Division, shall implement the multidisciplinary team approach to the intervention of reports involving severe maltreatment, and all reports requested by a prosecutor pertaining to law enforcement or prosecuting attorney investigations. DHS and CACD, or state police, are required to engage in interagency agreements, or MOUs, with local law enforcement, local prosecutors, and then other appropriate agencies and individuals. That has come to include our child advocacy centers as being another agencies, and then just mental health and medical providers over time. So MDT, or the multidisciplinary team, benefits cases by providing a space for a team of professionals to collaborate about the investigation and victim response. Each agency is going to have its specific responsibilities, but the MDT collaboration and accountability creates better outcomes and prevents children from falling through the cracks. Some of the benefits of the approach are going to be you're avoiding the duplication of efforts between agencies. It's going to foster child safety and provide parental support and assistance on our cases, allow members to have access to information that there would have otherwise been a barrier to accessing. Generally, it's going to assist law enforcement or our prosecutors in generating additional evidence on their investigations. Provides accessible, relevant, comprehensive victim services and more immediate access to those victim services. Reduction in the number of child interviews, access to trainings for our teams. We, as the state chapter, are required to provide and facilitate training for our teams across the state and our facilitators that run our teams. Other approaches are going to be increased likelihood of prosecution. This was seen going back to where the initiation of the MDT approach was because of the lack of conviction rates and prosecution on our cases. And this approach was primarily adopted to meet that need, but over time we've developed to increase the access to services and make it a holistic approach to child abuse cases. Increase access to 404B evidence and witnesses. So that's going to be what a prosecutor can use to increase sentencing and to increase just knowing what all cases have been involving either a child or an offender in the past, to bring those in a specific case. Awareness of a child's emotional state, and this is where your role would come in, access to specialized medical providers, the team's overall increased capacity to make more informed decisions, access to trained forensic interviewers, and just the camaraderie from a network of peer support and expertise. In my role, prior to joining the state chapter, I'd worked for 20 years on rural and urban MDTs, and I can tell you that the culture that can come from a well-functioning team is much higher than what I had with the camaraderie of my own co-workers. So my teams were my families. That was who I worked with and operated with, and had a better dynamic and relationship with the team members rather than colleagues within my own agency that may be spread around the state. So what is MDT? There had been a culture in Arkansas where MDT has been synonymous with a meeting that you go to discuss the cases, but that is not true. A multidisciplinary team is the child abuse response team. Some of you may participate on an MDT. You are the team members. The child abuse response team is that multidisciplinary group of professionals from diverse organizations who are trained and equipped to work together in a coordinated manner to ensure the effective response. And we want to do that so that every child has access to every service that every team member has to offer, and has that in a timely manner. In Arkansas, the MDT membership would include representation from the Division of Children and Family Services, and that'll typically involve investigators, but sometimes it involves their case service workers, the Crimes Against Children's Division, local law enforcement at the various different levels, prosecution, so it's going to be your prosecutors, your victim witness coordinators, mental health providers who are trauma informed, specialized medical providers, children's advocacy center staff. At minimum, that would be the advocate and forensic interviewer, but it may also include the mental health provider if the mental health provider is contracted with or employed by a child advocacy center, and same for our medical providers. And then juvenile probation and the juvenile courts. So that could be probation officers, intake officers, attorney ad litem, CASA, Office of Chief Counsel. Some of those may participate on a full-time basis. Some of those can only participate in case-specific meetings with the team. However, they are part of our MDT. So just a little bit about the Child Protective Service component. We do have both DCFS and CACD who provide child protective services as part of our MDTs. Both conduct civilian investigations, one housed within the Department of Human Services, the other in the Department of the Arkansas State Police. DCFS is going to handle child maltreatment reports, but they're going to be lower risk, lower severity of cases, whereas CACD will investigate the most severe child maltreatment reports. You can see there are some examples of the type of reports that they may work. And then anytime a report comes into the child abuse hotline, if it is a low risk allegation, it may be accepted for the differential response pathway, which is more of a family involvement to try to avoid involvement in the investigative process and removal of children from homes. The difference between the two agencies is that CACD typically does not provide services to the clients, children or families. They have to coordinate with DCFS to provide services for victims, children, and family, either through voluntary and supportive cases, protective service cases, or foster care services if there is a removal of a child from the family. CACD has to coordinate with DCFS for safety assessments. This means that they can decide that there are safety concerns for a child. However, they cannot conduct a health and safety assessment, and that they cannot put a protective plan in place for the family, and they cannot remove children from the custody of their family. And while CACD works closely with law enforcement. They are the civilian investigative division for child maltreatment. So they must notify law enforcement on all of their cases that they're working, and should work and conduct concurrent investigations with local law enforcement. So CACD cannot make arrests. They cannot do any of those things, but their case may be folded into a criminal investigation. Our law enforcement partners would be the ones that would be investigating the criminal allegations of child abuse and neglect. They're the ones that would be able to make the arrest. They may forward an investigative file to our prosecutors. Law enforcement should be collaborating with CACD and DCFS if necessary to conduct those concurrent investigations. They do a great deal in providing to our teams background criminal history and information on criminal aspects of specific cases, but they can also provide that on other cases that may not be worked by their agency, but they have had involvement with a specific family or victim or offender. Law enforcement do have the authority to take a 72-hour hold on a child for protective services and coordinate with the Division of Children and Family Services regarding placement of that child. And law enforcement can refer children and families to a child advocacy center for services or for a forensic interview. So unlike other partners, in order for our child advocacy centers to conduct or provide services, it is typically going to involve a referral from DCFS, CACD, or law enforcement, and in some instances, our prosecuting attorney or courts. The prosecuting attorney is going to be the one who prosecutes the criminal cases. They have the ultimate decision-making authority regarding the disposition of criminal cases, the decision to proceed to trial or guilty pleas, to amend or discharge or dismiss charges, to make sentencing recommendations as to like years, how that should be served is made by the prosecutor. They should assist law enforcement, provide them feedback on how they're conducting their investigations so that they get good cases where charges can be made. And the prosecutor should consider input from this team in making those decisions. So while they have that ultimate decision-making authority, they should not be doing that without consultation of the team. And that could be input as to whether or not a child is ready to go to trial, available for trial, whether or not this should take a plea, and if the child should be made to testify or not, and that would make a determination as to whether or not they should engage in plea bargaining with defense. They engage in preparation for our child victim and witnesses for court and trial, and there'll be more about that later in your involvement in that. A victim witness coordinator will be one that is employed by a prosecutor's office. Their roles vary across the state, but generally they provide a variety of informational referral and personal support services to crime victims and their families in court-related cases. So while we may have victim witness coordinators participating on teams, they only provide assistance in cases that result in cases being handled by the prosecutor's office. They serve as a liaison between the prosecutors and victims and our teams and our victim advocates, and share information with our advocates and work heavily with them in trial preparation. Our juvenile courts, the juvenile division of the circuit courts handle cases involving juveniles and their families related to dependency, neglect, delinquency, truancy, FINS, family in need of services. So they get involved on the team. They can provide team input and information on any family who's involved with the juvenile court system. And the team can work with them on any court order treatments that need to be involved. The attorney ad litem's and the CASA, or the court appointed special advocates, become involved with case specific meetings. So they have an opportunity, if they have a foster child that there's an open case on, they have opportunity to ask information and have that information available for their dependency and neglect proceeding. So our children's advocacy centers. So as a community-based program, our CACs are designed to meet the unique needs of the communities they serve. And as such, no two CACs are going to look and operate exactly alike. They're founded on this shared belief that child abuse is a multifaceted community problem, and no single agency or individual or discipline has the necessary knowledge, skills, or resources to serve the needs of children and their families. Our child advocacy centers are nonprofit organizations, so they're unique in that every other member of the team is going to be a government-based organization or entity, whereas our CACs are nonprofit. There are 30 locations across the state for our child advocacy centers, and they range in what services they're able to provide and how often they're able to provide that. They're available 24 hours a day, and all services that they provide are free to the family. So our centers offer a child-focused setting and a neutral setting where the MDT members can come together to work and provide services, treatment, have access to resources such as our forensic interviews that are available, or medical exams in a neutral, child-friendly location. So this is going to be the services that our CACs offer across the state. And like I said, these vary from center to center and from location. So we have 17 full centers that should be able to provide all of these, minus possibly the prevention or community awareness education, but they provide the core services, which are going to be advocacy, forensic interviews, mental health, medical exams, whether it's on-site or contracted out or by referral, or linkage agreements for medical exams with an outside hospital. Advocacy is going to be our advocates are our unique roles within our centers and on our teams that are typically going to be involved in and with our clients from the very start of an investigation all the way through the end of the investigation. So, and not only that, but they'll continue with that client and with that family beyond through their any kind of mental health treatment they're going through, and they can stay with that client until 18 if the client agrees. So they can potentially have a client that comes in at the age of 5, experience sexual abuse. They tend to their immediate needs, but they have ongoing needs, and they can follow that child until that child reaches the age of 18, and ensuring that there's access to services or just being there as support for them. Our forensic interviewers are going to be forensically trained in the Child First protocol. They provide access to our teams for our teams to be able to come in and watch interviews being conducted by somebody who is trained to conduct interviews in a neutral way, child-led way that is defensible in court. Then we have our mental health, and we'll get more into the mental health component, and then our medical exams that are going to be provided by specialized medical providers, whether that's a sexual assault nurse examiner or a physician, depending on the location of the center and any type of agreements they have with outside hospitals. So while a medical provider and a mental health provider may be a part of our multidisciplinary team through our child advocacy centers, it is unique that our teams could have a specialized medical provider and a mental health professional on the team that is not affiliated directly or employed or contracted with a child advocacy center. Our specialized medical providers are going to handle sexual assault examinations and kits. These happen in kids that from birth to 18. Usually they'll collect a kit if a sexual assault has occurred in the first within 96 hours. They can test for STIs and pregnancy and provide treatment or prevention of STIs. Some are trained to conduct drug facilitated sexual assault testing. So if there is if a child has been given some type of drug or alcohol during the course of a sexual assault or sexual abuse, and it's happened within the last 72 hours, toxicology could potentially be taken from the child. And that's not something that is always done. There has to be specific dynamics around that that requires that collection. They can take photos of physical injuries for our teams, and some, if they have the level of training, can diagnose physical abuse. That's generally going to be your nurse practitioners on your teams or your physicians with specialized training in child abuse cases. And then they work to provide education to our victims and our family and our teams about it's healthy to be normal. And sometimes, even though there's a sexual abuse, it results in a normal finding. And that does not mean that the sexual abuse occurred. As far as our mental health professionals, aside from just the clinical benefits associated with traditional psychotherapy, mental health treatment or involvement has direct implications for the child and family participation in the legal system. That's where kind of mental health has evolved into becoming a part of our teams. So much so that the National Children's Alliance standard for our child advocacy centers require that mental health services be made available as part of the MDT response. The relationship between mental health providers and other members of the MDT varies from center to center, and then also between MDTs. So some CACs have in-house mental health programs, while others refer their children out to families, to mental health providers in the community. And whatever the arrangement for providing mental health services, these mental health professionals make important contributions to the team. If you're not a part of a team, I'll connect with you on how you may become involved with teams. So whether you're on site or part of a referral, you provide services to CAC clients that are served by the MDT. You can either serve as consultants or provide the resources to the MDT and identification delivery of expanded services, whether that's going to be just mental health assessments, the actual treatments, crisis intervention. Your part on the team would be providing applicable mental health progress or updates on clients to the team in case review or as needed, and just offering an overall trauma-informed perspective and education to our multidisciplinary teams. Over time, there has been the question is whether or not other partners really have an interest or role in the treatment towards healing of our children, or does dealing with the identification and treatment of trauma have any benefit to our MDT members? And so, although some may question why they would be involved in the treatment process and their input be important for y'all, or a mental health provider's input be important for our specific team members, is that we have found that your role in providing specialized treatment and trauma-informed treatment for the clients allows a venue for, if they're able to continue with and keep track of the progress and they have successful healing on the opposite end, that our MDT members can respectively have an opportunity to celebrate positive outcomes of the clients, especially since once they're done with a case or they're done with a criminal prosecution of a case, they're typically no longer involved, and it balances out some of the negative impact of the trauma this work can have for them and the secondary traumatic stress. So specifically dealing with our mental health professionals on the MDT. So given your role on the team, it is important that mental health professionals have responsibility to receive specialized training in multiple areas and evidence-based modalities, whether that's going to be TFCBT or any other treatment lens modality that you prefer to use for your clients. You're unique on the team, that you can be a standalone member outside of a CAC. So traditionally for our teams, our mental health professionals are CAC based, whether contract or employed by a child advocacy center. However, in our rural parts of the state, community-based mental health providers are enlisted to fill that gap on our teams. Like an advocate, the mental health professionals are typically involved well beyond the end of an investigation, court processes, anything of that nature. So you have more connection to the clients and the families. And unlike any other role on the team, outside of potentially a medical provider, there's additional confidentiality concerns that exist. So it makes your role on this team unique. Types of mental health services that are expected from a mental health professional on an MDT is going to be trauma screening, assessment, identification of any treatment needs, identifying the appropriate treatment goals, and determining the most appropriate treatment to meeting those goals. If you can't provide that, making the appropriate referral for that treatment, and then just monitoring and case management of the treatment to its completion. So the role of the provider, the mental health provider on the MDT in that case review, is to provide that clinical information regarding clients. If authorized, because of HIPAA concerns, informed consent is always a necessary evil that must be addressed in your role with the teams and information that can be released. To provide information about trauma-informed and evidence-based treatment modalities to the team, what's most appropriate. I've found that in my prior role with the Crimes Against Children's Division, one of the things that we would typically try to ascertain out in the field is whether or not families had access to specific services and whether or not mental health services were part of what a family was already involved in. However, myself, I have never had any kind of specific training to go out and provide treatment, to assess the appropriate treatments that should be available for our clients and the children. And so, I would have the kid that is, yes, going to therapy for ADHD, for instance, but that therapist not really having the expertise that they need to be able to handle a child abuse, child sexual abuse, trauma resulting from trauma associated with child maltreatment. And so there is more deferral to our CACs or our mental health providers on our teams as to whether or not our children are receiving the appropriate services they need to achieve that healing. Another role on the team is going to be just discussing the impact of trauma on child victims and their caregivers, and answer any questions from the MDTs. Sometimes this looks like addressing behaviors that a child is exhibiting and how that's related to the trauma that they've endured, rather than being a defiant, delinquent child, and helping our team members understand that if we deal with a trauma, that delinquency or that defiance may resolve. As far as responsibilities for our mental health professionals on the MDT, each MDT shall have at least one mental health professional that's involved to the extent that they participate on case review. There may be multiple mental health providers that service our clients and are providing treatment to them, but ideally there should be an expert that sits on the MDT that's able to provide consultation to our teams as to referral for services, and if there's a need for a mental health provider to come in to discuss case specifics, there can be case specific meetings. However, ideally it would be just one mental health provider at a case review. Our mental health professionals may have to attend court, handle subpoenas, court orders, trial and witness preparation, and just the expertise on the availability of a child for our prosecutors. And they should provide leadership in monitoring treatment to successful completion for our MDTs. The ways that this can look for a mental health professional and their service delivery for our CAC clients or our MDT clients is that there can be case-specific involvement. So in some cases, what this would look like is that the mental health professional provides treatment only and does not interact with the MDT beyond just taking the referral. Thus, the mental health professional does not release case-specific information to the team unless there's something that is reportable by law, there's a signed HIPAA release, or a valid subpoena from a court overseeing the case. Another situation that would arise is that the mental health professional may attend case review for specific cases with which they're involved to hear the status of the investigation and to share information on safety concerns, the family status, or perhaps the child's state of mind and ability to testify. And then a third way would be that the mental health professional may also serve as in that consultant role, attending the case reviews without specific knowledge of or relationships to the children who are being discussed, but helpful to identify the particular mental health concerns relevant to the cases under discussion. So kind of going into your role as a mental health professional, it's going to start in most instances, unless you are currently involved on an MDT, is going to be as the mandated reporter. And so I feel it's important to highlight that, you as a mental health professional are a mandated reporter in Arkansas, and you shall immediately notify the child abuse hotline if you have reasonable cause to suspect that a child has been subjected to child maltreatment, has died as a result of child maltreatment, or observes them being subjected to conditions or circumstances that would result in child maltreatment. What this looks like for you and your role, and if you are a mental health provider with a child prior to the report being made, is the question is whether or not there's privileged communication that protects you. Some mental health professionals and medical professionals believe that privileged communication laws prohibit them from reporting abuse, and that's incorrect. Privileged communication laws do not always apply in cases of child abuse. There is a legal obligation to report any suspected abuse or neglect of any of a child known to you in your professional or official capacity. And the only exceptions for privileged communication would extend to attorneys or clergy. And if you fail to report, you can lose your license to practice in your profession. So anonymous reporting. Mandated reporters presently have a right to make an anonymous report by calling the toll-free number. But it's important for you as a mandated reporter that you need to know that if you make a good faith report to the hotline, you're entitled to immunity from legal liability. And if you make the anonymous report, there is no legal proof that you fulfilled your role as a mandated reporter. You have certain rights to access to information as a mandated reporter. However, if you report anonymously, you will not have access, because there's no means to reach to you to get that follow-up information for your purposes. And then it also weakens our cases. So the investigator is not able to contact you to verify information. And a lot of times we find that if you may be the only other person other than the child that has any information about it, and if the child is not prepared to discuss that with the team, with CACD, DCFS, law enforcement, or any of our other members, then that case may get unsubstantiated or no criminal action taken. And so it reduces the likelihood that we will be able to have a determination in a case and just overall weakens it. And I want to point out to you that recent legislation that was passed this session, so Act 727 deletes language allowing for anonymous reporting by anyone, including mandated reporters. So while presently you have this right to make an anonymous report, when the new legislation takes effect towards the end of July, that ability will be removed. Act 727 also removed the ability to make a report to the child abuse hotline by fax. So the only means to be able to make a report when this law takes effect is going to be by phone or by the new mandated reporter portal. It does add another class of mandated reporters to include persons 18 years of age or older who observe abuse, sexual abuse, and sexual exploitation of a child. So these are things that are going to have to be considered when you're dealing with your clients or the parents of your client, and any information that they now hold as to who makes that report. It's a mandated reporter's liability isn't diminished because another person makes that report or another mandated reporter makes that report. And then if a parent now observes physical abuse, sexual abuse, or sexual exploitation, they are now defined as a mandated reporter. And so when you are consulting with your clients or your families, that information should be shared with the families if they need to make the report. And especially if you're getting it secondhand from the parent, getting the information from the person who has direct knowledge is usually going to be the best. Something to consider as far as the dynamics of when a report shall be made. It says immediately. A lot of times that has been interpreted as being within 24 hours of you having coming into that knowledge about the report. However, the timeliness of that report being made to the child abuse hotline can affect safety concerns and the collaborative approach with our teams, and how all that comes together. So if a child comes into a therapy session, discloses that information to you, say right now, and you make the report at 4 p.m. after you see your last client for the day, and that report goes to our on-call with our respective agency, whether it's assigned to DCFS or whether it's assigned to CACD, and they then prioritize based on the type of allegation that's reported on how quick they must respond to a specific case. So it then may be another 24 or 72 hours for them to make contact with your client about that abuse. And so the quicker that you're able to make that report between the time that you've received that information is beneficial for the child, for their safety, for the investigation as a whole. And if you're not familiar with the mandated reporter portal, I recommend going and creating an account to do so, since that will be the best, easiest means for you to do it without being placed on hold and dealing with the wait with the hotline. So kind of what that looks like when you come in and you make that call, the hotline is going to screen that report for acceptance, assign it a priority, and assign it to the appropriate agency for a response. And at any time, while you're mandated to report it to the child abuse hotline, if it's an emergency, you'll report that to law enforcement and have them get involved on the front end, because there is that potential delay when it gets assigned to CACD or DCFS. So it'll either be assigned to the Arkansas State Police Crimes Against Children's Division or the Division of Child and Family Services based on the priority. Each type of allegation is given a predetermined priority that is assigned to it. So a sexual abuse penetration is automatically, when it comes in, is going to be a priority 1, which means 24 hours, whereas a threat of harm to a child may be a priority 2 assigned to DCFS, and they have 72 hours to make contact. These are all outlined between an interagency agreement between DCFS and state police on who is assigned and works what types of investigations, the priority of response for those agencies. And so the hotline just has to make the determination as to whether or not the information you provide to them is enough for that report to be accepted as child maltreatment, assigns it to those agencies. The priority and everything is already pre-established. It goes to them. Those agencies are the ones that are required by law to engage in that MDT approach that involves all the different MDT members. They should be coming together to allow a child to have access to CAC facilitated services, whether it's the medical exam, if it's a sexual abuse, advocacy and support on all cases, a forensic interview, if a forensic interview can be done in a timely manner at a child advocacy center, and that's going to be the best practice and preferred approach. But there will be circumstances that require, sometimes in emergency situations, to take place out in the field. And then there should be ongoing MDT engagement with these team members throughout the life of the investigation. And then those partners on the team could engage the MDT even after an investigation is closed and request that a case be brought back on to rediscuss and ask for case-specific meetings. This is kind of a more in-depth look at the flow of a case as it comes through. And so you'll have the suspected report. There should be the dual report to law enforcement and to the child abuse hotline. The hotline can decide whether or not a report will be screened out. And if they screen out a report, meaning it doesn't rise to child maltreatment, it would go to law enforcement, and law enforcement can investigate it. They can accept it to investigation and assign it to CACD or DCFS, or they accept it to go to that differential response pathway, which is also done by DCFS. As far as the MDT goes, the MDT does not handle all cases that come into the child abuse hotline. So there are pre-designated cases. The MDT approach is designated for our severe maltreatment cases. So any case that goes to CACD would go through our multidisciplinary teams, whereas only a handful of the cases that go to DCFS come before our MDT. And that may typically involve threats of harm, failure to protect, and physical abuse cases, and then also Garrett's Law, which are going to be children that are born with drugs in their system. So those cases come through the MDT for DCFS. It goes through and talks about like the initiation of the report, referral for services, and you can kind of see going on down what the flow looks like for the cases. Everywhere that you see a gray bubble here, or a little bit darker shaded bubble for case coordination, this is the opportunity for the appropriate MDT members to come together to discuss and strategize on how best to proceed into a next step. So our team should be talking, and at appropriate places, you may need to interject here, your role as a mental health provider, and what that may look like is you talking with this team before they go out to initiate as the managed reporter, and speaking to them about whether or not this child is going to be best suited for interview at a child advocacy center, whether, you know, if there's going to be any barriers to that initiation and involvement with a family, down to the forensic interview that takes place, any other services that are being provided, the ability to do charges and proceed with this in a criminal investigation, any sentencing, as well as on the safety side for the child maltreatment investigation. This works through, and this is how a investigation or cases flow through our MDT response. And involved in our MDT response is going to be a case review function. So our case review is the forum by which we come together. It has been in the past referred to as our MDT. That is our child abuse response team. This is our case review meeting. So for this process to work, our MDT members need to truly work together as a team and respect and value each team member's point of view. And no one agency has all the information, has all the expertise. And so it takes the information that you're able to provide and share and contribute to this to really work and function well. It's important to understand that this case review meeting is not only for sharing information, but also for team decision making and being able to decide what's appropriate for this client or child. Once an investigation is complete, law enforcement, DCFS, CACD, they have limited to potentially no contact with the family, whereas the mental health professional in your role may work with the family for months after the investigation is complete. You'll be able to form this strong and trusting relationship with the clients and their families. And you're in a unique position to recognize the strengths and potential risks for a family and to learn what that family's greatest concerns are related to the investigation and its outcome, or even any upcoming involvement with the court process. Thus, that sharing of information between you and the team can be beneficial to both the family, but to the team's effort to conduct a thorough investigation and successfully resolve the case. During this case review portion, it's important to understand your role in case review and have that thoroughly understood by the other team members that are involved, especially where confidentiality laws, including HIPAA regulations, come into place and how that extends to clients' mental health records. You're legally and ethically bound to adhere to those laws. So informing and educating our team members on, you know, how that impacts what you share, your role and participation on that team, understanding that if you are the one that's providing treatment as a component of the MDT approach, that you should practice and have appropriate procedures in place dealing with informed consent, with your families and or tailoring your involvement in the service delivery, whether it's case specific or just consultation for the teams, based on that dynamic and having that worked out while you're on a team, before you join on a team, if you're not currently on a team. And just know that any information that is shared in these case review meetings is confidential and not to be disclosed, absent appropriate authority to do so. Whether you have any other laws or regulations or practices in place with your local team, your local center, or just laws in general that allow for redisclosure. Otherwise, it should be confidential. So this is just a map for any who are not familiar with our child advocacy centers and our locations around the state. Ones that are not presently reflected is that we do have a new location in Madison County, which is going to be in Huntsville area. We have a location that is being developed in Johnson County and locations in Hot Springs and Nevada County that are providing services. These, though, reflect the centers where if you're not involved and want to become involved as a mental health professional with our centers, whether it's through linkage and referral-based systems, whether it's a contract provider for our CACs or as an employee of our CAC, I encourage you to reach out to our child advocacy centers, the executive directors, and inquire how you can become involved, but also acknowledge the gap. There is a large gap here in our state that does not have access to a child advocacy center or not readily accessible to a child advocacy center. So there may be ways that you can coordinate with myself or a local MDT facilitator in your county or your region to participate on those teams to provide that expertise for our teams moving forward. I know that we do work with our Arkansas Community Mental Health Centers, and so there are some rural areas in the state that have participants from our community-based mental health providers. And if you do have any interest, I do welcome you to reach out and contact us. And at this time, I'm going to turn it over for questions. And I'm just looking here in the Q&A.
Yeah,
Yeah.
you can jump in there, or I can ask them to you, however you want to do it.
I think the first one, it says, did feel that there is a breakdown with prosecuting offenders of child abuse, and do you feel that reform is needed? So I'll move those over where everybody can see them as well and read them along. But so yes, I greatly do and feel this on so many different levels, and it varies across the state with regard to prosecution of our cases. It becomes very difficult for our prosecutors to want to risk prosecution of these cases because of the dynamics involved in child abuse and primarily our child sexual abuse cases. Because a lot of times it's reliant on just a victim's statement rather than other corroborating evidence. What we have found is that most people, and that the average age of disclosure for a victim of a child victim of sexual abuse is age 55. And so when somebody's not disclosing until they're age 55, can you imagine that there's not that evidence available from an incident that happened when they were a child to go back and prosecute those? But even those that are doing it, it's generally going to be 6 months or after an event before it's disclosed. And any evidence that's going to corroborate that case, especially where it comes to our sexual assault kits, which our prosecutors feel is our smoking gun, must be collected or should be collected within the first 96 hours of an event. So if unless they're a client of yours in advance of an event happening, rather than becoming a client because an event happened, the likelihood of that happening within that time frame is slim to none. It's very few of our cases. Are there any trainings available to primary care providers on how to ask questions or work with a family that they suspect there is abuse going on? So registration has been closed for this particular round. However, we at the state chapter are now offering kind of a what to expect in child abuse cases. And so we have taken the basics of understanding child first training that our forensic interviewers have and scaling it back down for those who are not forensic interviewers and don't need child first, but need to understand the disclosure dynamics, understand how to ask questions. It really comes down to the minimal facts and getting that information of a child, allowing it to be child-led, asking them what, where, when, and not when as to how many times, but when was the last time something happened. And that really helps an investigation determine whether or not there needs to be a medical exam, whether something is more acute or not, generally where it happened, whether it's location of somebody's house, where we can determine appropriate jurisdictions are working those cases, and just the narrative of what happened. Tell me more, tell me what happened, rather than trying to ask suggestive or leading questions. Those are typically what you're going to get, but we will be having that training available in the future as well. So I'd recommend just going to our state site, and I can include that information in these slides that will be provided to annotate to release, so that you have available and other resources that are available, and connect with any trainings that we're offering surrounding child abuse cases in our MDT response. I recently worked with an individual who made a report, but the family was told who made the report. Is that supposed to happen? So absolutely not. Reporter information, whether it's a mandated reporter or any other reporter, that information should not be disclosed. There's laws protecting that. The only instances where a reporter information can be disclosed is going to be that it can be disclosed to law enforcement, it can be disclosed to a prosecutor, and it can be disclosed upon a judge ordering that information to be disclosed. So if there's a dependent neglect proceeding or an ongoing criminal proceeding, and the courts feel like it's necessary to have that mandated or that reporter information, then it can be ordered by a judge. So I'd question how that individual came into that information. Definitely, if you find that instance has happened, definitely make the report to the agency that is happening, because that's there to protect our reporting institution, and how we protect our children in the state.
Great. Well, that's all the questions it looks like that came through. But thank you so much, Marquette. That was a really helpful, informational presentation. I learned a lot from it, and I've been working with you guys for a long time, so I still have a lot to learn about it. And I think that's really helpful to see how all the pieces fit together. For everyone, I will share these slides. I'll send those out to you. If you're interested in a CEU, I will email out a link, the survey that you can take, and then you will put in the code 2504, and that will email you your CEU. So that's all we have for today. But thank you again, Marquette, and thank you all for participating. We will not have an Our Best webinar next month in May. We'll take a break, but we'll have one again in June. So stay tuned for that, and have a great afternoon. Thank you.